Hey, good morning, everyone. Welcome to your morning briefing, our monthly webinar series that is designed to keep you up to date on timely and important topics in the labor and employment law area. I'm Amy Hemenway, a partner with Harder, Seacrest, and Emery's Labor and Employment Group. And today I'm excited to introduce Troy Snelgrove, our guest speaker, who's joining us from Employer Services Corp. This morning, Troy and I will be walking you through practical tips and important considerations for preparing EEO-1 component data, which is due in just a few short weeks. We'll also provide a few updates on recent positions taken by the EEOC and the U.S. Supreme Court, which relate to employment discrimination. Before we dive into our topic, I would like to provide a few points of information that will help you get the most out of today's webinar. First, our webinar is approved for HRCI and SHRM credit. We'll give instructions on how to apply for that credit towards the end of the webinar. The information we share today is for general information purposes only. It shouldn't be taken as legal advice. If you have specific questions on legal risks for your organization, please reach out to one of our attorneys. All participants are on mute during the webinar. If you have a question, we're happy to try to answer it for you. Just please use the Q&A widget on the toolbar to submit the question. We'll try to answer those in real time as we go through the webinar, but we'll also save time at the end to catch any that we haven't answered yet. With that, I'm going to turn it over to Troy, let him introduce himself and tell you about the EEO-1 data collection.
Thank you, Amy. Good morning, everyone. I'm Troy Snelgrove from ESC, and today I want to walk through some tips for preparing and submitting your EEO-1 data. And I also want to talk through some common pitfalls to avoid so you can ensure that you have a smooth and accurate filing process. So let's start with a quick refresher on what exactly is the EEO-1 report. The EEO-1 report is a mandatory report from the EEOC that collects workforce demographic data, specifically looking at race, ethnicity, gender, and job category. This report is required for private employers with 100 or more employees, whether individually or through common ownership, and also for federal contractors with 50 or more employees and contracts of at least $50,000. The data that is reported is based on a workforce snapshot, which is a single pay period between October 1st and December 31st of the reporting year. In the case for this year, it would be a single pay period between October 1st and December 31st of 2024 that we are now reporting on in 2025. Also for this year, the EEO-1 reporting deadline is Tuesday, June 24th. So for those of you watching today, you would have just under 2 weeks to complete your reporting requirements. Now, let's talk through how to prepare for your reporting obligations, because a little planning can really save you a lot of stress as this deadline approaches. First and foremost, I always recommend organizations start early. Don't wait until the last minute. As soon as that reporting window opens, begin working on your report submission. You can even pull and review your data ahead of time, and I recommend most organizations do this, so you don't need to complete that part of the process as soon as that reporting portal opens. Now, let's talk a little bit more about what data you're going to need. First is that workforce snapshot that I mentioned before, which is that one pay period between October 1st and December 31st of 2024. From that snapshot, you'll need to report on the race, ethnicity, gender, and job category for each employee that was active during that period. For multi-state employers or employers with multiple locations, you'll also need data for each establishment, as you'll have to report on each location individually. Also, accuracy is important when you're completing this report. Make sure your HR, your payroll, your employee demographic data are all aligned. It's a good idea to review the job classifications also and ensure that your roles are classified in one of the 10 EEO-1 job classifications correctly. And if you are unsure as to which position, what it should be classified as, the EEOC does provide a lot of helpful resources to employers on their website where you can review and see where that job should be reported under. Those EEO job classifications include executive and senior level managers, first and mid-level managers, professionals, technicians, sales workers, administrative support, craft workers, operatives, laborers and helpers, and lastly, service workers. I know I went through those very quickly, but there are only 10 of them. And if you're unsure again on where your positions may fall in one of those 10 categories, utilize those resources that the EEOC provides. They're extremely helpful to employers in determining where those positions should be classified as. Through that step, make sure that you have your organization's EIN number, your NAICS code, your legal name, and address available for this step. You're going to need to input all of that information so that the EEOC can link your organization to your reporting account. If you have any issues during this stage where you're setting up your account or trying to get access to it, the EEOC does have a filer support team that you can contact that is very helpful to assist you in any part of that process if you encounter a roadblock. Also, don't forget about technology during this stage as well. Many HRIS and payroll systems have automated reports that you can pull that will generate your EEO-1 report for you that you can simply upload. I always recommend, though, to review those reports for accuracy, because if you don't have all accurate data within your HRIS system, your report may not be accurate when you generate it. One thing that we'll talk about a little later, but I see commonly at this stage, is if an individual declined to state their race or ethnicity, and that's in the system, but when you run your report, it's not having the correct ethnicity assigned to that individual. And finally, submit on time. Missing the reporting deadline can lead to a lot of issues that you and your organization just don't want to deal with. So keep in mind that deadline. So let's move on to the common pitfalls we see when organizations are completing their EEO-1 reports and how you can avoid them. First up is missing or incomplete data. This is a big one and one that I see most commonly. I always recommend to do a pre-submission review to check for any missing or incomplete data. Make sure all employees are accounted for and their demographic details are complete. Employers do have to offer the employee the opportunity to voluntarily self-identify their race, their ethnicity, and their gender. Employees are generally given this opportunity to do so when they complete their new hire onboarding paperwork. But if an employee chooses not to provide any of that information, the EEOC still does require the employer to report on that information. You simply just can't leave that field blank if an individual declines to state. In situations like this, the EEOC directs employers to use what's called observer identification, where the employer should make a visual observation to determine where that individual should be reported under. Another common issue that I see come up is incorrect job category coding. It's very easy to misclassify roles, especially if the titles maybe are a little ambiguous or it's a very unique position. So take the time to review your job description and see what EEO category they should be reported under. As I spoke about briefly before, the EEOC does provide very helpful tools for employers to utilize in this step of the process. Another pitfall that I see happen somewhat less commonly, but I still see it happen sometimes in organizations, is relying on outdated demographic data, where they just utilize the previous year's data rather than pulling that workforce snapshot from the previous year and reporting on that most current data. Next, for multi-location employers, forgetting multi-establishment reporting can be a problem. If you are a multi-establishment or multi-location employer, you would need to complete a Type 4 report for each establishment and then a Type 2 consolidated report for the entire company. When you do go in to do your reporting, there are questions that you have to ask at the very beginning of the reporting process in the portal that help the EEOC determine what type of report you should fill out. So it will really guide you to the correct spot. So just answer those questions and you'll find the correct reports that you need to utilize. The last pitfall I want to discuss is failing to review the report for errors. This might seem obvious, but it does happen. Before you submit your report, audit your data and check for any inconsistencies, any errors, any missing information, especially if you're using the manual entry feature of the reporting portal where you're keying in that data manually. It's very easy to have a missed keystroke where you have too many or too few employees in a certain category, and then your counts would be off. So if you follow what we discussed here and avoid these common pitfalls, it will help you ensure you have a smooth and accurate reporting process. I'm going to turn it back over to Amy now to discuss some new legal updates related to the EEO-1 reporting.
Sorry. Thank you, Troy. Those were really helpful tips. And I think those will be useful as our listeners work towards gathering the information they need and getting their reports in order to be submitted within a couple of weeks. I want to turn to a couple of recent updates from the EEOC and the US Supreme Court that relate to employment discrimination law. First, when the EEOC issued its press release opening up the EEO-1 portal, it included some commentary that dealt with how to use the EEO-1 data. And essentially, what they said was, don't use the EEO-1 data to make employment decisions that are motivated by an individual's protected status. So when people are collecting the data that they're going to put into their EEO-1 report, they may be inclined or interested in seeing what the trends look like year over year. Have they increased specific categories of individuals, whether it's minority-based or gender-based within different job categories? Have they lost percentages of diverse individuals in particular categories? And oftentimes employers are interested in that. They may also look at data based on departments or specific job titles because they have the data in front of them and they're working with it. It's very important for employers to understand that they should not use that data to make decisions that are based on or motivated by a particular protected status. So, for example, if an employer were to observe that year over year, or looking back over maybe the last 3 years of their EEO-1 reports, they've decreased the percentage of females in the workplace, they wouldn't want to then begin to alter their hiring and recruiting strategies in order to specifically make decisions based on gender. That's not to say that they can't make improvements within the recruiting and hiring process that would benefit all applicants and potential employees, in the hopes that it may also have an impact on increased female applicant and hiring decisions, but they can't make decisions that are specifically motivated by gender in that instance. So they really need to be careful about how they use the data that they are collecting. And that was something that the EEOC specifically flagged. The EEOC also in that press release reiterated its view under the current administration that any different treatment based on protected status is discriminatory, no matter which groups are impacted, whether that's minority or majority groups. And the reasoning there, or the thinking there, is that oftentimes employers will make decisions or change practices or policies to try to correct a perceived deficiency, and the unintended consequence of that is, or perhaps the intended consequence of it, is discrimination against the majority group and disadvantaging the majority group, stripping them of opportunities. So the EEOC continues to be focused on that as a position under this administration, and it just means that employers should be looking carefully at the data that they are collecting, how they're using it, what types of decisions they're making based on it. And then somewhat related to that, but a little bit different, last week, the US Supreme Court issued a decision addressing the appropriate standard of review in reverse discrimination cases. And this is an area where we've been seeing increased activity, more charges, more lawsuits. There's more attention around this as a topic in blogs and articles that we're seeing. So in the decision, which was Ames versus Ohio Department of Youth Services, the US Supreme Court resolved a circuit court split over whether plaintiffs in a reverse discrimination case need to provide additional background proof beyond the traditional prima facie case. So, for a very long time now, courts have examined intentional discrimination cases using the McDonnell-Douglas framework, which is, a very simple prima facie case. In decisions, the Supreme Court has said this isn't a rigid application. It should be flexible. The threshold is very low to meet the prima facie standard. In several circuits over the last several years, the courts have ruled that a plaintiff in a reverse discrimination case needs to provide some additional proof beyond that prima facie case to establish background evidence to support the notion that the employer in the case is one of those unusual employers that would discriminate against the majority, right, in favor of a minority group. And if the employee that's suing can't provide these additional background circumstances, the court will dismiss the case. And other courts have disagreed and said, no, McDonnell Douglas applies. There's no additional background information that's required or additional background proof. So there was a circuit split. The Supreme Court unanimously, right? We've seen a lot of split decisions from the court, but they unanimously came down and said, no, Title VII does not require additional proof beyond the traditional McDonnell Douglas prima facie case in order to support a reverse discrimination claim. So in that case, Ames was a heterosexual woman. She alleged that she was denied a promotion and demoted based on her sexual orientation and sex. She was claiming that straight women in that particular workplace were the majority group. Her direct supervisor was a homosexual individual, and the individuals promoted over her and that took her place when she was demoted were both gay. And so she was claiming that her sexual orientation, being a female, was the reason that she was not promoted and then was demoted. And prior to that, she had had generally positive reviews. So that was a reverse discrimination case, and the court again reaffirmed the notion that the McDonnell Douglas standard of review remains the standard for addressing intentional discrimination cases. And in affirming this principle, the court reasoned that Title VII doesn't focus on a particular minority group. It's not focused on females. It's not focused on a specific race. Instead, Title VII protects classes, race, gender, religion, and it focuses on individuals. And so any individual who is, based on their status would be protected, whether they are in the minority or the majority within that protected status. And so based on the court's ruling that there is no additional proof requirement and the EEOC's position that Title VII, extends to everyone, we're not going to tolerate decisions that may work to favor a group. We expect to see an increasing trend or this trend of increasing reverse discrimination claims to continue. To minimize that risk, employers should review their employment decisions carefully and ensure that they're supported by legitimate reasons. And, don't just look at, is the individual in a protected status minority group, but look more broadly at, okay, how have we treated others who have engaged in the same types of behavior or who've experienced the same types of performance issues? Have we been consistent and even-handed in how we have addressed these? Have we made exceptions? If we have, how does that person compare to the person we're looking at now? And you want to involve HR in those decisions. And if you have any questions, you should certainly be reaching out to your attorneys to talk through potential risks that may be associated with an employment decision, whether it's, denial of a promotion, a decision to promote, or a termination, right? So any employment decision really should be reviewed and ensured that it's supported by legitimate business reasons. Before we turn to questions, I do want to take a moment to provide our HRCI and SHRM codes. So we're going to have those put up on the screen, hopefully. Okay, so our HRCI credit code is 709305. Again, for those who are looking for HRCI credit, the code is 709305. And our SHRM code for this webinar is 25-DPUY6. The SHRM code again is 25, D is in dog, P is in puppy, UY6. So if you are looking for credit, you can put those codes down on the sheet that should have been emailed to you and send it back, and we'll make sure that you get the credit for attending today's webinar. So at this point, we'll take, I do see there's one question in the chat. If there are any others, feel free to put those in. And this is, will the recording be shared? And yes, we do share the recordings. So if anyone wants to share it with a colleague or missed something and they want to go back and listen again, they're certainly welcome and able to do that. If there are no other questions, we'll let everyone get back to their day. We finished a little bit early today, but that's not always a bad thing. I know it's a busy time of year for everyone. We do have our next webinar will be scheduled sometime in July, so please stay tuned for that. I'm sure we'll have a timely topic for you. And if you ever have suggestions, you can certainly feel free to email any of the attorneys in our group, and that is something that we certainly want to make sure we're providing topics that are of interest to everyone. So thank you for your time today. And Troy, thank you for joining us. It was great to have you. And I appreciated your thoughts on the EEO-1 component data collection.
Thank you, Amy, and thank you everyone for attending.
Right, thanks. Oh, I just want to make sure we don't have another question that came in. Nope, okay. All right, thanks everyone. Bye.